Welcome to episode 3 of For the Good of the Game, a podcast where we examine the issue of public interest litigation through the lens of one case, the challenge to stop the 1985 All Blacks tour of South Africa. Where we left off last episode, the legal team had everything they needed to start proceedings. First, they had a legal argument, the two very technical points identified by Ted Thomas, and the broader argument, identified by Rodney Hanson, that the rugby union had not acted in the interests of rugby in New Zealand. Secondly, they had two plaintiffs, Paddy Finnegan and Phil Recordon. They were not the first choice of plaintiffs, but nevertheless the lawyers believed they could prove that the plaintiffs had standing to bring the claim. The issue of standing will be the main focus of this episode. Paddy Finnegan and Phil Recordon's claim was filed in the High Court in Wellington on the 20th of May 1985. The rugby union responded within a few days. They applied to strike out the claim, that is, have it dismissed by the court before it considered the claim in full. The rugby union claimed that the case should not go to a full trial because it was frivolous, vexatious, and an abusive process. One of the main reasons for this argument was that they claimed the plaintiffs did not have standing. The rugby union instructed the lawyer Douglas White to represent them in court. I asked Douglas White why the rugby union decided to apply to strike out the proceedings.
Two players had no right to challenge the decision.
And that was on the basis that they weren't members of the union?
Yeah, well, the only members of the New Zealand Rugby Football Union were the provincial unions, and the process, if they'd wanted to raise the issue, was to go through their club, the university club, which then could have raised it with Auckland, which then could have raised it with New Zealand.
Douglas White looked at the constitution of the rugby union, the same document that Rodney Hanson had used to build the plaintiff's case. As we discussed in the last episode, the constitution said that the only members of the rugby union were the provincial unions, such as the Auckland Rugby Union. But the plaintiffs weren't representatives of the Auckland Union. Technically, they weren't even members of the Auckland Union. They were members of rugby clubs that were affiliated to the Auckland Rugby Union, which was in turn a member of the New Zealand Rugby Union. On behalf of the New Zealand Rugby Union, Douglas White argued that the plaintiffs didn't have the standing that was required to bring their claim. The case was heard in the High Court in Wellington on the 6th of June 1985. The judge was New Zealand's Chief Justice, Ronald Davison. When deciding cases, judges apply the rules set down in previous cases, known as precedent, to the facts of a case before them. Sometimes, where necessary, a judge may slightly alter the established precedent in order to do justice to the facts before them, and some judges will do this more than others. By reputation, Chief Justice Davison was not one of those judges. He had a reputation for strictly applying the established rules of precedent, an approach that is known as legal formalism. In the High Court, Justice Davison carefully went through the precedent cases which set the laws around membership of incorporated societies. He agreed with the rugby union that the plaintiffs were not members of the rugby union. He also found that neither Paddy Finnegan nor Phil Recordon had any contract with the union. In applying the precedent of previous cases, he found that a case could only be brought against the decision of an incorporated society if the plaintiff was a member or if they had a strong interest in the decision, for example, if their employment was at stake. Neither of those circumstances applied to the plaintiffs in this case. The Chief Justice accepted the rugby union's application and struck out the proceedings. He considered that they had no possibility of success at a full trial. The case had failed at its first hurdle, but it was not all over yet. New Zealand's courts are structured with a hierarchy of appeals. Someone who is unsuccessful in the High Court can apply to the Court of Appeal for leave to appeal. If they are given leave, they can then try to persuade the Court of Appeal that the High Court has made an error and have the original decision overturned. That is what Finnegan, Recordon, and their lawyers did. The Court of Appeal sits with a panel of at least 3 judges. In this case, the court sat with a total of 5 judges. One of those judges was a man named Robin Cook. Justice Cook is regarded by many as one of the greatest judges in New Zealand's legal history. He was also known to have a different judicial philosophy to Chief Justice Davison. While Justice Davison was known for strictly applying the rules of precedent, Justice Cook was more creative. He would often innovate to find new legal approaches to suit the needs of a particular case. His supporters describe this approach as creative and flexible. His critics describe it as judicial activism and criticise him for overstepping the role of a judge by creating new laws. The Court of Appeal's judgment in this case is a good example of Justice Cook's approach to law. The court unanimously overturned the Chief Justice's decision, and it was Justice Cook who wrote the judgment. The court agreed with Justice Davison that there was no direct contract between Paddy Finnegan and Phil Recordon and the New Zealand Rugby Union. But that was not the end of the matter. Instead, the court decided that a more flexible approach was necessary. In a ruling that is typical of Justice Cook's approach to law, the court decided that every case needs to be considered on its own to decide whether there is sufficient standing. Justice Cook gave 8 reasons why he thought that in this particular case, the plaintiffs had the right to sue. First, although Paddy Finnegan and Phil Recordon did not have contracts with the rugby union, they were linked to it by a chain of contracts. They were members of clubs who were affiliated to the Auckland Rugby Union, which was a member of the New Zealand Rugby Union. The court described the plaintiffs as people for whom basically the organisation exists. The second, third and fourth reasons given by the court all recognise the importance of the challenge in the context of the rugby union's role in New Zealand society. The court recognised that the plaintiff's claim was directed at a fundamental matter of the rugby union, being one of its central objects, promoting, fostering and developing the game of rugby in New Zealand. Furthermore, the decision was important to the future of rugby as a national sport. Justice Cook described it as least as important as, if not more important than, any other in the history of the game in New Zealand. Overall, the decision affected New Zealand as a whole, and not just the rugby union. The fifth reason given by the court was that the rugby union needed to be treated differently from other private organisations. Instead, it needed to be treated a bit as if it were a government department. It was an organisation in a position of major national importance. Accordingly, some legal principles from public law, the field of law which concerns citizens' relations with the government, needed to be considered. In that area of law, standing is easier to prove because government decisions can sometimes affect everyone in New Zealand. Try to remember this point. We'll be discussing it in more detail in the next episode of the podcast. The eighth and final reason is perhaps the most controversial. I'll read it here in full. As a result of the disturbances accompanying the 1981 South African tour of New Zealand, many citizens, including normally law-abiding citizens, were alleged to have gone too far when indulging in protest activity. The importance of preserving law and order was rightly stressed. The courts applied the law impartially. There were numerous prosecutions, many of them successful. It is now no less appropriate that the lawfulness of the union's decision under its own constitution to arrange the proposed tour should be open to test in the courts. This reason was certainly unusual and highly creative. Essentially, the court was saying that since it had become involved, one way or another, in the issue of sporting contacts with South Africa in 1981, it should stay involved in the issue 4 years later. I asked Douglas White what he thought of this reason.
Still don't quite understand what that's got to do with the issues in this case. Because they were criminal offences, and of course the law had people who are perfectly entitled to demonstrate, but if they've committed a criminal offence, then they'll be prosecuted. No one ever suggested the rugby union was proceeding in a criminal fashion here. Completely different issue.
Perhaps unsurprisingly, Paddy Finnegan has a different perspective.
A lot of law-abiding people have found themselves before the courts where the lawfulness of their actions are subject to judicial scrutiny. It does not seem just as reasonable that the lawfulness of the rugby union's decision should be subject to scrutiny by a court. And I thought, well, that's not a bad observation.
The two judgments on standing are interesting because they illustrate two very different approaches to law. Douglas White recognised this at the time.
Well, there are two views. I acknowledge that. One view is that the law can be used in these creative ways to achieve these wider objectives. That's one view. There are two legitimate views as to how the law should operate in these political, social areas.
Justice Davison's decision is an example of legal formalism. It applies traditional precedent from incorporated society's law without adjusting that precedent to the unusual and particular facts of the case before it. It does not consider the wider context of the case in the course of its reasoning. The Court of Appeal's decision, delivered by Justice Cook, displays what some people would call judicial activism, the consideration of wider political or social factors in the process of legal reasoning.
Many of the 8 reasons given by Justice Cook, including the controversial 8th reason, had no precedent as justifications for standing. Instead, they placed the case within a wider political and social context and determined that the case was enormously important to New Zealand society. John Minto, one of the leaders of the protests in 1981, believes that social and political factors such as the growing opposition to the tour played a significant part in the court's decision.
What Cook is saying there is that this was not a minority. By 1985, this had become a majority issue. The sense of majority of people were very wary and concerned, and that issue had gone on for many years, and most people now were sort of in a sense on our side. Yeah, so I guess it's a reflection of that.
At the end of this episode, we're left with some important questions. Should the court be used to test moral, social and political issues? Should these factors play a role in the way that court decisions are made? In some way, the Court of Appeal decision in this case gives some possible answers. By allowing the plaintiff standing on the basis of very broad considerations, the Court of Appeal was saying that it believed it had a role to play in these complex issues. In a way, the court recognised that sometimes we cannot place a clear line between issues that are only legal or only political. We'll come back to this question in more detail in the final episode of this series. In reaching its decision, the Court of Appeal established its own precedent. The Court of Appeal's decision has been cited in many New Zealand cases where plaintiffs are trying to show that they have standing. What the decision shows is that, particularly in cases where there is significant national interest or the exercise of public power at stake, the courts will not take a formal approach to standing. Instead, they are more likely to let the issue proceed. Before we end this episode, there is one other observation I'd like to make. In this case, there was an important difference between the lawyers for each side. As we've already seen, the lawyers for Paddy Finnegan and Phil Ricordan were fighting for a cause they believed in. In fact, it was them, and not the plaintiffs, who had started the whole process of challenging the rugby union in court. The lawyers for the rugby union, on the other hand, were doing what lawyers normally do. A client had come to us for help, and they had agreed to represent them. This does not mean they endorse the rugby union's decision. In fact, Douglas White has never told anyone what his personal views on the tour are. Everyone has a right to legal representation, and lawyers should not turn down a case because they don't believe in the cause. This principle is known in legal ethics as the cab rank rule. In taking on the rugby union's case, its lawyers were performing an important ethical duty to represent their clients as best they could. In the next episode of For the Good of the Game, we will finally get to the main trial in the High Court. We'll see how the lawyer's argument fared and what the judge eventually decided should be the outcome of the case. This podcast was made with funding from the New Zealand Law Foundation and support from the University of Auckland Faculty of Law.